court has been attempting, frankly, all day to get through the reading of jury instructions, to get to the point where the parties make their closing arguments, and ultimately to put this case in the jury's hands. It has been challenging. It has been met by resistance from Mr. Brooks. I would once again describe it as being stubbornly defiant, although at times he may.
You were just listening in to earlier comments from Judge Darrell. Let's take you out live here on Live Now from Fox, as Darrell Brooks will likely give closing arguments himself. We currently aren't hearing any audio out of this stream from the courtroom, but of course they're slowly gathering back inside this courtroom in Waukesha, Wisconsin. This is, of course, a live look as Darrell Brooks back inside the main courtroom here, not in the adjacent courtroom, as we continue to wait for this trial to resume, these closing arguments to resume, with Darrell Brooks representing himself in this Christmas parade attack from Waukesha, Wisconsin in November of 2021. Of course, jury deliberations could begin later on today as we await the closing arguments. Obviously, depends on what happens over the course of these closing arguments, and also the ruling from Judge Darrell. The judge said has been challenging, to say the least, there.
The record should reflect that Mr. Brooks is now present.
This ongoing trial. Let's listen in live on Live Now from Fox.
Following the break, I did invite him back into the courtroom, and he is here. I trust you are ready with your closing argument, sir.
I'm ready to address subject matter jurisdiction as well, too.
That request is denied.
Just for the record, I was addressing it for both courtrooms here in courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the jury out. Are you prepared to present your closing argument?
I would like for you to prove subject matter jurisdiction on the record, Your Honor.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you of that.
In that written decision, did I receive, well, actually, I didn't receive anything. Was there copies made?
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There's no other legal arguments I need to address from you at this time.
I'm informed of what you're saying. I was merely asking, was there copies made of your, you said written decision?
Sir, my written decision has been filed into the record. That is done electronically. You were provided with a written copy previously. Are you asking for another copy of that, sir?
Yeah, because I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
Is it proven subject matter jurisdiction?
Your objection to the lack of jurisdiction has been noted repeatedly on the record. It is a meritless argument. I've indicated that in my written decision as to why there is subject matter jurisdiction, and I will continue forward with the final stages of this trial, which I hope include your closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I
defendant.
accept for value and return for value this document, as it is not based in lawful law, and it does not prove subject matter jurisdiction whatsoever. Refers to some complaint that was filed in the name of a trust, not my name. Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Were you aware of that?
Please be prepared with your closing argument.
Were you aware of that, Your Honor? Or is that a tacit agreement that you don't have to answer any questions as a public servant?
All rise.
So that is a tacit agreement.
Record to reflect, the jury is coming out. Thank you, everyone. Please be seated. Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
So this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why the jury deserves to
Mr.
need
Brooks,
to
this
know.
is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30-plus pages to read.
Did you inform
They will
the
be
jury?
informed of the law.
Did you inform them that they
Mr.
can nullify
Brooks?
the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you, one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
That they are-
Brooks, you
that
have
they
no
have
right
the
to
power.
make that argument to the jury.
It's true. They have the power.
All right, I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury. Thank you. Please be seated. Mr. Brooks, you do not have a right to request jury nullification directly from this jury. I direct your attention to the Bjerkas case, Bjerkass, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able to mute half of what you said the second time, and then of course you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice, so you can't coerce me into a constitutional right waiver when I have not waived the constitutional right, and I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a judicial determination that you're denying me a constitutional right in
I have
open
not
court
made such
on
a
record
determination as of yet, but you can forfeit your constitutional rights
under
by
what
conduct.
lawful law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
In
closing
State versus
statements.
Anthony,
Illinois
the Supreme
versus
Court
Allen.
of Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of those
the
that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how's that same statute being used for something that it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are two examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular defendant.
And that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
Which I was denied the
I'm
right
not
to
prepared to
be
make
able
that
to
ruling
testify to.
here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument. There will be no further delays.
It's
I
not a
will not
delay.
be taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing arguments.
And you made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
No, once. So let's
Twice.
make that correct. Once.
That's the third time.
Okay, now you can say two.
So, Mr. Brooks, I'm advising you yet again. The time
I don't
has now
consent to
come.
being called
That's
that
another
name, Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You were
And-
brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be informed of the truth. It's not me
Are
trying
you
to
telling
give.
me, sir, that
it's
you
not
are
trying
going
to
to
give.
let me ask you a
No, hold on.
question.
I'm not trying to give any
Sir,
jury
you're
instruction.
interrupting me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury nullification?
That's not what I said.
That's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, you may not argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have the. You just said on the record that they have the power for.
Sir, I direct your attention
you just said that.
once
Did you
again.
not just say that, Your Honor?
Sir,
You
the
said
jury,
I couldn't instruct them.
the jury
on
has
that.
the power, but not the right to nullify.
Right.
A
You said the
party-
power. You said the
Listen
power.
to me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
I'm
that
not
you are
telling you no
going
such
to
thing. I
disregard
just told you what you just said.
my directive to you to not raise the issue of jury nullification during your closing argument?
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Bjerkus says and stands for the proposition that although the jury has the power of jury nullification,
They have the power.
no party has the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I
In
just
that
want them to be
case,
informed.
the-
I just want them
Sir,
merely to be informed.
You can
That's it.
call it informing, making them aware.
Yeah, they
Whether
should be aware
you
of
are
the
not
rights.
allowed to make them aware of their power to nullify. That
How
is
can
an
I not make them-
improper argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that
not
is not a
inform them
right
of a
that
power
you
that they
have, sir.
have? I'm not giving a new jury instruction.
That is
That's not what
because
I'm
there
arguing.
is no jury instruction for jury nullification,
Yeah,
sir, because it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
Mr.
That's not
Brooks,
against the law.
I'm advising you one more time. You may not raise the issue of jury nullification before this jury.
Inform them of the power that they have. I'm not
You are
giving them.
telling me
I'm
that
not
you
giving
are
them a jury
insisting
instruction.
on telling them about jury nullification. That's what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying. You just read and said that they have the power. They have the power to do that. So how is
It's
informing
an
them?
inherent power that they have. They are not to be instructed on it. That is very clear in the law. In
Your
addition to, no, let me finish. In addition to the case that I just cited, I'd cite to you from the jury instructions the law note on jury nullification 705. What that says, sir, is I'm not going to read it all. It's many, many pages. But the bottom line is it is improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware that they have the power to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork because I brought that up. So you never intended for this to even be an issue.
Mr. Brooks,
it never was brought up.
If you
but
think
then when I raised the issue,
if you
Your Honor, let
think
me
that
finish.
I'm not prepared to deal with an argument on jury nullification,
I didn't say
then you
that's not what I said. That's
You are
not what I
missing the
said. In
mark.
all fairness, that's not what I said.
The record should accurately reflect that you were kept in that holding cell.
Why was I kept
so
in there?
that my clerk could finish
Adding a jury instruction that was not there.
76 verdict forms, and it's ×2 because there's a guilty and a not guilty
Okay.
for each. No, let me finish.
So
You've
why did
interrupted me
I have why did I
repeatedly.
have to sit here for that where I could have just went to my cell and had it delivered? We had this
Mr.
at the end of last night before you called recess.
I'm not going to debate
we had a
that
whole
topic with
we
you
had a whole
further.
conversation about
Mr. Brooks, you
me
are
bringing up about the jury
defiantly
nullification.
disregarding this court. You
Here we
you
go
can
with this.
roll your eyes
Here
at
we-
me
because
all
it's,
you want.
It's ridiculous, Your Honor. You just stated that they have the power to nullify
Would you
any
like,
law,
if you would like,
but then
I
I
will
said
read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom, but that is oftentimes what I need to do in order for this court to make a full record without you interrupting me. But you need to be fully aware that you may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
under what lawful law?
Under State versus Anthony.
It doesn't refer to that.
State versus Anthony
it
may
doesn't.
not have dealt with
It hasn't dealt with
the
closing
right
arguments.
to a closing argument, sir, but the reasoning
You just said it right there.
nonetheless is
No.
fully applicable.
No, you
because the more
can't. You can't
general
change the law, Your
principle-
Honor. You can't change the law. That's
I'm not
practicing law
changing
from the
law,
bench.
sir, but the general principle.
I know you used to be in legislation, but you can't practice law from the bench.
Sir, I'm
You
not
can't do that.
practicing law from the bench.
You are if you're changing. Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I
Allen.
would like to make a record. Would you please show the courtesy and respect for
I
me
will,
to
Your
do
Honor.
that?
I will.
All right. So looking at the Anthony case, all right, and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which a defendant may give up his rights, waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there, I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture, doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S. 337. They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument. That is my ruling.
I object to that ruling, Your Honor. I object to that ruling.
Are you willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power. Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time did
telling
you, hold on, Your Honor, with all due respect, I'll let you make your record. I didn't interrupt you.
Go ahead.
Not one case law that you just cited made any reference whatsoever to a closing argument. Not one. So how is me merely informing the jury of the power and the rights that they have, how is that a forfeiture of being able to give a closing argument?
Well, in addition to the cases I've just cited, sir, I'd also point you to State versus Bajirkis, 163 Wisconsin 2nd at 549. That's a Court of Appeals case from 1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presented with arguments that are proper under the law. I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now. I'm the only one that has to be made rules for closing arguments, but not the prosecution. How is that fair? How is that balanced?
Mr. Brooks, I am squarely faced with your defiance regarding the issue of jury nullification.
It's
that
not
is
defiance.
Requiring
It's
me
not defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
Your objection is noted for the record, but
May
my
I ask
rule
for legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling. For the record, may I request a legal or factual basis for your ruling? Not one pertaining to being present in the courtroom or testifying. One that specifically talks about a closing argument.
All of those requests are noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot
Well,
answer that.
You referred to it before.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm confused, Your
to
Honor,
a court of
because-
appeals, not this court.
No, this is, I'm supposed to be in this admiralty court because you haven't, if we're under Article 3, then we should be in common law court. That hasn't even been addressed, if we're in a common law court or an admiralty court.
That's a baseless argument, sir. I don't even
And
need to
what law and
address it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you an opportunity
I'm informed of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also,
please let me, sir, you're interrupting me yet again.
You just tried to put me under a rule that no one else was put under.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't,
on
Your
the
Honor,
issue
that's a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
It has to be
circumstances of
fair.
this case and your insistence on arguing jury nullification has resulted in
I
this
haven't-
court creating this
I
rule.
haven't argued it. I said that I wanted to inform the jury of their power. I never once said I'm going to make an argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that they have the power
And why
of
not?
jury
Why can't
nullification.
they be informed of their power?
Because it would violate the Bajirkas decision, sir.
Violate what decision?
All right, sir, I am going to bring the jury out.
And I'm going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to present
You
a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based upon
Then I make a
how
oral,
I've outlined that to
motion
date.
for a
I'm
legal
not going to
finding of
declare that
fact.
at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't
to
do that.
Present a closing
Under
argument.
what lawful law can you?
And then if you continue to
Under
interrupt
what
me,
lawful law?
you will be removed to the other courtroom as I complete
So I'm being
the
held in
instructions.
contempt again. Is it civil or criminal?
Your
All
Honor,
right. Go ahead.
I apologize. May I ask the court to consider perhaps an alternative, and I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant in his petulance will say jury nullification in the first 3 seconds the jury's in the room.
Objection
The-
to that.
Proper
I don't
thing
think
to
that
do,
I
I
should be
think,
talked
Your
down
Honor.
Stop
to.
interrupting,
I don't
Attorney
think I
Hopper,
should be
please.
talked down to.
allow him to make his closing argument. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction. This court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require effort for the court to allow this to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
I'm certainly willing to try that.
It's about all we could come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom, and if he disregards that, to excuse the jury and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Agreed.
Your Honor, I object to that.
Your objection is noted for the record. That will be the course of action that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
All right, with that, let's bring the jury
For the
out.
record, may I respectfully request the legal reconsideration of your ruling? So is that a tacit agreement that you don't have to answer my objection, Your Honor?
I decline to reconsider.
I reject that ruling and take exception to that ruling, Your Honor.
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Denied.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction.
Denied.
Under,
The jury
based
is
on
coming
what
in.
law or
All
fact?
eyes for the jury, please.
Based on what law or fact? Because I'm going to inform the jury of their power. They deserve to know.